You want me to hold it?
কালকে কে নেবে? হ্যাঁ,
আইএসএ মামলা
কালকে কে নেবে মামলা? হ্যাঁ,
ইউনিয়ন অফ ইন্ডিয়া
তা বলছি না, কালকে কে মামলা নেবে?
কেউ নেবে না, তো বলছে তাই করা ডিপার্টমেন্টের
Lordship,
Your Lordship.
may I, Lordship, may I be permitted to mention one very urgent matter from Honorable Justice Rajashri Bharadwaj bench, presided over by Lordship Bharadwaj bench. Lordship, election of trade union to be held on tomorrow, that has been stayed by the learned single judge. The matter was fixed today. Lordship, Bharatiya Mazdoor Sangh has filed this application. Lordship, kindly hear this out. Only sole ground it has been stated that Steel Authority of India has no branch outside West Bengal, but admittedly it has many branch in many state. The learned judge has hold that the election should be took place by the register of the state authorities. Already it has been declared by the central authorities. That is why we have filed, Lordship.
Election is tomorrow.
Lordship, tomorrow or today, anytime.
Please don't make such.
Tomorrow, Lordship, at
Where, from where can we see?
election is tomorrow.
Where, from where can we see this fact?
Petition. Lordship, election schedule is attached to the petition. This is the order of the learned single judge.
Show us the election date.
Petition. Petition. Lordship,
Come with the petition.
Lordship, I am coming with the petition.
not maybe permitted, and my lord, serial number 95 of your lordship's today's list. Now the matter is preferred by the Union of India. Now, my lord, a contempt application is pending before the learned tribunal. Now, my lord, this matter pertains to compassionate appointment. Now, my lord, the next date is on 12th of June. Now, my lord, if we comply with the order, then, my lord, we have to give them the appointment. The writ petition would become infructuous. Now, my lord, only a limited purpose, my lord, is being sought for, so that if it is maybe taken up urgently, my lord, before the next date, my lord, that is the 12th of June.
You mention on 9th, don't worry. 9th, the
9th, my lord, then liberty be given. If it is taken up on 9th, my lord, I shall serve upon the.
you in the meantime you serve, you tell them, you mention on 9th, don't worry. You have 3-4 days the other side. We'll hear you, don't worry. Yes.
As your lordship.
Your Lordship, may I be permitted to mention a matter?
Yes.
Your Lordship, this is a contempt matter, Your Lordship. It has been specially assigned to Your Lordship with Honorable Justice Proceedings Biswas yesterday. Your Lordship, it's a contempt matter. There is some urgency. If Your Lordship could take up the matter tomorrow, Your Lordship, for 5
This-
minutes, Your Lordship.
This is not the bench where you are.
Your Lordship. Yes, Your Lordship.
This is not the bench to which it is assigned.
Your Lordship, it has been assigned to Your Lordship along with Honorable Justice Proceedings Biswas
What is the urgency? Why tomorrow?
through yesterday's notification.
Why
Your
tomorrow?
Lordship, it's a contempt application.
Contempt. So what is the urgency? Why it can't wait till the other side of the holiday? That you have to tell us. Every contempt can't be taken up tomorrow. Yes. All the best.
Item number 1,
Yes, the writ petition is dismissed. Keep it in mind.
item number 2,
He is appearing in the matter. Yes, dismissed.
Item number 27.
You were the right.
My lord, I appear for the petition, my lord. Lordship heard us yesterday.
Hmm?
My lord, your lordship heard us yesterday, my lord. Matter relates to, my lord. I have not challenged the charge memo, although the tribunal came to finding that the charge memo was under challenge. My lord, my case was, my lord, simultaneously departmental proceeding and criminal cases pending. I want stay. My lord, that was my prayer in the original application, but the tribunal came to his finding that as if I have challenged the charge memo, and my lord, the matter was dismissed, and my lord, writ petition is pending.
Oh, yes, on the premise that the charge memo
Yes, sir.
cannot be assailed. The other
Lordship,
issues are required.
Lordship, in
What I am beseeching is this, my lord. As your lordship has said, my lord, let the order passed by the learned tribunal be set aside and remitted back to the tribunal, my lord, for fresh consideration.
Lordship,
This is my prayer, my lord.
the tribunal has considered the entire aspect. It's only in the ordering portion that this is because whether it's the pendency of a disciplinary proceeding and the criminal prosecution, Lordship, the entire judgment has considered all those aspects, whether a departmental proceedings should be stayed or not. It's only at the end that this finding has come, Lordship. Under these circumstances, what I was really praying for is, Lordship, whether it should be sent back because
Was for consideration. And when is the next date fixed?
The matter has been dismissed, my lord. Tribunal has dismissed the matter, my lord. They have no other option.
Proceeding has been dismissed.
The proceeding will trigger to no, my lord. It's on
is
2nd of
the-
June. 2nd of June.
Then we'll hear you in the first week, both of you.
Lordship on the
We'll hear you in the first week. On 2nd June, just don't
let's
proceed.
second Lordship.
Don't proceed any further on 2nd June.
My lord,
The Learned Council for
The schedule of the election.
Dekan.
Everything has been completed, lordships. Only election to be held.
This is only a schedule. This is a schedule. This is not fixing a date.
Lordship, tomorrow is
We don't know. Tomorrow the bench, if it is not there, you come in the morning. We'll see. Give it back.
Item number 3.
my lord. I am for the state, my lord.
Not press this app. You have client instruction, Mala. This is
Not press. You have instructions.
because what trial before the tribunal, Mala, it has already withdrawn, Mala. So
Withdrawn.
withdrawn.
And the order, the writ arises out of an interim order.
No.
Or
Order
an order
directing
during
to
pendency.
extending the time for filing opposition.
We are informed by Mr. Swen.
Item number 4.
Lord, I am for the appellants. Lord, it's appearing for correction, my lord.
Correction. What happened?
My lord, there are some inadvertent mistakes, my lord. My lord, page number 1, paragraph 2.
क्या है? किसी केस का है? Is it from some case? No. Or it is disposed of.
Yes, my lord.
Paragraph 2. What is the?
Paragraph 2, line number 4, my lord.
Yes.
My lord, the appellants have stated that the other writ petitioners of WPA number 22060 of 2023 proceeded to file the appeal without intimating to the present 5 writ petitioners. Instead of writ petitioners, it will be appellants. We are appellants before your lordship.
Yes. What else?
Now next, my lord, para 6, second word, my lord. Instead of appellants, it will be, instead of petitioners, it will be appellants, my lord.
Para 7.
Para 6, word 2.
Yes.
Next, my lord, thereafter, para 9, my lord. Para 9, 6th word, my lord. Same. Para 9, instead of petitioners, it will be writ petitioners, and again on appellants. Again on 1, 2, 3, 4, 5. 6th line, my lord. Petitioners, instead of petitioners, it will be appellants. Paragraph 9.
না এটা তো ঠিকই আছে, 9টা তো ঠিকই আছে।
Thereafter, my lord, para 12. Second line, instead of petitioners, it will be appellants.
অ্যাপ্লিকেশন ছিল তো।
Petitioners, and then in the next line, writ petitioners.
Second line, yes. Para 12, second line, petitioners.
Yes.
Instead of petitioner, it will be appellants. And again on 4th line, my lord, first word, petitioners. Thereafter, my lord, para 13, writ petition. The writ petition is disposed. Instead of writ petition, it will be appellants. Appeal disposed of. Thereafter, my lord, point 14, para 14.
Appeal. Para 14, appeal.
The appeal stands disposed of. That's all, my lord.
Very obvious mistake. Third land counsel for the petitioners.
Item number 5.
Yes, in this
I,
matter,
my lord, I am
for
appealing
the
for the petition.
respondents, just for correction. When your lordship disposed of the application on 13 May 25, when can you see first page of the order? Instead of Diamond Harbour, but it should be typed as Superintendent of Police Baruipur.
First page,
Yes, what a last sentence. Representation before
instead of Diamond Harbour, it should be
it as Baruipur, because it's a Baruipur police district. And another in that page 2, response number 3, paragraph 6, SP Baruipur.
My lord, earlier, my lord, that was
paragraph 6.
Malad,
Paragraph 6.
paragraph 6. Person. Representation respect the claim before the SP Baruipur. Instead of response number 3, it would be SP Baruipur.
Respond number 3. Who is respond number 3?
Initially there was only one district, Diamond Harbour. Now it has been 3 districts, police districts. South of Raghunas, Diamond Harbour and Baruipur.
in my lord, it will be respondent number 3. Now the SP Baruipur.
That should have been corrected in the cause title of the writ petition itself.
Lordship grant leave to amend the that would be better. Because initially a petition was filed when only one district. Now it is been 3 districts, South Raghunas,
Now it is truncated into 3 districts.
3 districts, Alipur, Diamond Harbour and Baruipur.
And council, the matter has been listed at the instance. Let her correct the, let her correct.
Amended with the
This I have changed. That's changed, but this I did not change because non-respondent number 3 is different, already corrected. It need not be changed. Non-respondent number 3 is very important. This thing need not be changed, but there it has to be. Only one place we have.
Item number 6.
Wait, please, Your Lordship. No, I'm appearing for the appellant.
My lord, I have got the respondent number 2. My lord, it is after a lapse of 2 years, my lord, all on a sudden this matter appeared. No notice was given to me.
Why, how it has come up?
My lord, it is assigned matter.
Lord, but we mentioned the matter, I'm told, and it was mentioned upon notice.
And subsequent thereto, I requested learned advocate that way, what would be that? Yes.
Indicate what the point is. It's a very small issue, my lord, which is
Yes.
for consideration. My lord, there was a delivery made by us in December 2013. A letter of credit was opened. My lord, the delivery was accepted. No dispute with regard to anything with regard to the delivery, my lord. It was unilaterally amended, the LOC, in January 2014, 6th of January 2014. The issue which falls for consideration is, my lord,
Lord, whether
once
private dispute will be
once
treated
the
as a writ
contract-
application or not. That is the main
My lord,
questions.
Lord,
The
the
judgment
issue
was
is
like that.
there is no factual dispute. On a factual admission, my lord, the issue which falls for consideration is whether a unilateral amendment of the LOC can be done once the contract is, my lord, accepted. In fact, it's a concluded contract where the delivery was made. We can come back on the reopening, my lord. I'll indicate from judgments that
Yes, done.
It is rising out of an order passed by the Honorable
My
Single
lord,
Judge.
page 116, page 116 of the, my lord,
It's
the
a
memo of
appeal.
memo of appeal. The
From
writ
the last paragraph of the first page of the order.
साफ करवाओ इसको क्या एवरी हर फाइल में बोलना पड़ता है साफ करने
But the main point here, my lord, is one line which has been recorded by the Honorable Single Judge. That is a writ court. I am not minded to enter into the disputed question of facts. I'll indicate it's not a disputed question of facts.
If your lord please kindly fix this matter 1 week after vacation, my lord.
he has got it fixed today.
We can come back after 1 week after vacation. If my learned friend is taken by surprise, I don't want to, my lord, put him into any
Let's
job.
see.
We can come back after vacation.
Let's see.
Yes.
Let us see the order at least.
Yes.
before.
We'll come back thereafter, sir, after the vacation.
Not even open the file. Sir.
Oh. এটা দিয়েছি তো না
না
আসতে
And the state petition is page 116, and the memo of appeal, my lord, it's also annexed.
is
Only
this
one.
scan number?
Let's scan one. The old number is 8394 of 2017, my lord. 8394 of 2017.
One. Wait, 2016. 2016.
And the order under appeal is dated
21st June 2017.
So what is wrong with the order?
Now, there is no disputed question of fact here.
He is not saying it is disputed.
But it is indicated, may I only indicate the first page below the last paragraph.
No, there is no question of disputed question. Does the bank admit that they have unilaterally changed it?
Yes, my lord.
They say that we have unilaterally changed it.
Between two banks.
We are asking you a simple question.
Not sure.
There is a change the Honorable Single Judge has recorded.
I know.
Now, is there an admission that they have unilaterally done it?
Yes, my lord, because we have not, my lord.
There is an
accepted-
admission that they have unilaterally done it.
May I humbly submit, my lord. That itself, you know, the fact that they have done it unilaterally is not.
We
evidence
don't
of
know
words.
whether it is unilateral or not. That is which is
That
what
is
has to be.
will be, my lord.
No,
To
that is what
indicate
has
the
to be
records.
established. We are not to go into such
No,
an
no,
issue.
it's not on the facts. It is
We
not on the
don't
facts.
find any infirmity in the order.
I'll indicate
Sorry.
from the documents on record. Kindly.
We will not look into this. Is not the forum to go into it.
Yes,
Sir, I'll
this is my
Precisely what the Honorable Single
I'll
Judge has
indicate,
said.
Lord, the honorable
And we
single
don't
judge-
find any infirmity in what he
Kindly
said.
permit me, my lord.
Yes.
The honorable single judge has held there is no.
Read the order.
I've seen. May I
Please read it.
It appears from the narration of events, as noted above, that there is an
There
amendment.
is an amendment.
There
So
is
there
an-
is no
I'm very
dispute.
clear.
What you are saying is clear.
That's not what is falling from your lordship.
Yes.
Lord, the query which is falling from your lordship is, where do I find that it is unilaterally done by the bank?
No. Unless it is admitted, how it can be
Unless
looked
it is
into?
Lord, I'm
How can it be looked into by a writ
From
court?
the
Cannot
narration
be.
Of the facts, I'll indicate
It
that
cannot be decided in a writ proceeding.
Lord, may I very humbly submit? It will not require.
No
a
point in
decision of
keeping
the
it
honorable
pending.
court.
No point in keeping
Lord,
it
kindly
pending.
grant me one
Please, you
opportunity.
avail the opportunity that you
I'll indicate the facts.
appropriate remedy in accordance
Yes.
with law. That is all
I'll
that has
indicate the facts here
Yes.
before your lordship.
not required, sir.
My lord, otherwise I'll fail in my duty, my lord, to indicate why this observation of the honorable.
You are
Single-
very sanguine. It has been done unilaterally. You will show us 10 documents that look, we did not agree to this.
No, my lord, I
Still, we will not.
10 documents. I will only show, my lord, the chronology of events that will
Not
suffice.
required. We
That
are
is a
not
dead-
here to examine that.
It is not required, my lord.
It is not a
examination.
jurisdiction of
Today-
to look into such issues.
But may I
But
only
it is
humbly
a
submit
private
this?
dispute. Even if it is a private dispute.
Court has also not held that the
My lord, there are several judgments of the Supreme Court and as well as this
I
Honorable Court.
rely on a few judgments, my lord.
Unless
where-
we call upon you, don't
Very-
interject.
very well.
Please. This is not the way.
No, very good.
It's not a open market that everyone will start shouting. Yes.
But there were few judgments, my lord, which I'll place reliance on, which
Yes.
say, my lord, in these situations, my lord, if there is a unilateral amendment which is not admitted per se, but what is required, and those are in writ proceedings, my lord, all that is required to be seen from the facts of the case is whether, my lord, in this situation, there is any concerned document by which, my lord, we have conceded. Here, my lord, the facts are, after the
They
delivery
are
has
not
been made-
required to show us. Why should we call upon them to show us?
So it's not required.
Then
I'll show from my records that it is unilaterally done. There is no inquiry required.
that is
before
your
the report.
allegation and that is not admitted. That is a
That's what I-
dispute. That is a dispute on a question of fact.
My endeavor
Whether
would
there
be-
is such a fact in existence or not is to be seen. What is the appropriate forum? You tell us.
May I only indicate this? Kindly grant me 15 minutes on the reopening I will
Why? We
try
are hearing you right now. We
because
have
I'm
seen
not
it.
carrying those judgments. That's the only difficulty I'm facing.
Then why did you mention it?
Because my learned friend said
Then
that.
why
he will
did you
give me
mention
more
it?
time.
See, unless we find any reason, we may not call upon him. It is
But-
a appeal arising out of a single judge judgment. We are not required to hear him.
Only pray for this, my lord. One day, my lord, kindly permit me. I'll carry the judgments. I'll place the judgments before your lordship and I'll leave it to your lordships.
As
This
jointly prayed by the parties.
I'm very deeply obliged.
Deeply obliged.
Item number 7.
For the respondent. হ্যাঁ? না এমনিতে প্রথম দিন আসছে তো এটা তো ফার্স্ট ডে আসছে আজকে তো ফার্স্ট ডে Yes, come to the two prayers in the earlier way and the present way. What is there? Just see at page 2 of the tribunal's order. Very well, you told us yesterday. The prayer made in the first way is noted in para 2. The prayer made in the second way is also noted. Where is the distinction between the two prayers and why an OA should be filed for the same relief twice? That is the only issue.
Yes, my lord. That is the only issue.
Yes.
If you allow me to read those two orders only the ordering portion, then that will help.
The prayer.
Yes, ma'am.
Page 2 is the prayer in para 2 of the earlier OA.
Do issue further mandate upon the respondents, their men and agents, each of them to forthwith grant and release family pension to the applicant with effect from the date of her entitlement, that is from 13th April 2019, and arrears thereof till date, and pay 18% interest of the said total due arrears amount of such family pension to the applicant, and to continue to pay family pension to my
No,
applicant.
this is substantially the same prayer
My lord, but
made in the earlier OA.
yes, my lord. But if we read the earlier order,
The earlier order directs passing of an order. Where have you assailed that order?
my lord, practically,
Where is the prayer seeking quashing of the order passed pursuant to the earlier order? Show us.
my lord, I'm just only on one point. My lord, the tribunal, the earlier, the Central Administrative Tribunal has given a specific direction.
Therefore, we are asking you, where is the prayer assailing the order passed pursuant to the earlier order? Why do you need to tell us all the facts when we are already telling it to you?
Yes, my lord.
There's no prayer. What is wrong with the tribunal's order? You have come for the same relief twice. The first occasion, there was a direction. You were to file a representation. They were to file and pass an order. You have not challenged the order. Same relief. How it can be done?
My lord, we have challenged that order and we
You
have moved.
show us the prayer, sir. You are saying will not do.
Just kindly. Dated 8th November 2022.
It is very much quoted in the order at para 2. There is no such prayer.
My lord, if the first prayer, if we read the first prayer, an order to issue directly the respondents to take up the case of the applicants for grant of family pension with the ministry stroke DOPT as advised by Pay and Accounts Officer DOCA Kolkata at an early date and to convey the decision to the applicant. It is indirectly deemed that the order has been challenged and that is the reason.
Oh, very
why-
nice.
My lord, then
Now the court has to
allow me
deem
the-
all the prayers for quashing of all
but
the orders.
court has refused it on another point. The court has
It is not refused on another point. It has said that for the same relief you have approached the tribunal twice. Please read the order. Using expression res judicata does not make it any different. It is for the same relief you have come twice. Earlier a relief was granted. You have not challenged the order. Without challenging the order, how such a direction can be issued? You tell us. Without challenging the order rejecting your claim, can a tribunal issue an order to give you family pension?
My lord, the issue before the tribunal on the second occasion was only on the point of res judicata. That it has already been heard by the tribunal before. But
That we can clarify in one line. That will not help you. You have to answer the question that we are asking you.
My lord, then
It's nothing. It's nothing. We asked him, we gave him so much opportunity yesterday. How can you just tell us when there is you have approached the tribunal? Earlier there was some mandate that they will not give you family pension. You ask them to resign those orders and to issue a direction for payment of family pension. The tribunal said, all right, the authority will consider.
Yes.
Authority has passed an order.
Yes.
You don't challenge the order. You again come to the tribunal that direct them to give me family pension. Can it be done?
My lord, then please give me an opportunity to annex that application which has been made before the tribunal.
Sorry. Annex it where? There was no such prayer in the tribunal. What do you mean annex it? This is not here to mend all these things.
My lord, if we go through the application before the tribunal, which is at page number
Annexing a document without challenging it. And then you will proceed on that basis.
that is a technical error which has been committed.
That's
an error which has been committed.
That's not an error. That is a conscious omission to make a prayer. It is not if you have made the prayer and the annexure has been marked and not annexed. Therefore, it is a inadvertent error.
My lord, for getting justice, my lord,
For getting justice, you are not required to do anything.
yes,
You are not required to do anything.
No, that is the mistake on my part.
So what can be done?
let the
We are here only to see what is the infirmity in the tribunal's order, nothing more. We are not the tribunal.
My lord, may I be given an opportunity to file a elaborate application before the tribunal challenging the order of the officer?
We don't know what you will do.
Otherwise, I will
do
lose my opportunity, my lord.
See the way you have filed the OA. See the way this court is being burdened with unwanted litigation. One docket addition to the tribunal, one docket addition to the high court. No prayer made as per the relief claimed. And now another OA before the tribunal.
My lord, if an opportunity is not given to the petitioner, she's a
Learned counsel Grateful, Your Lordship. See, when there is something simple and there is something irreparable, how can you mend it? You cannot mend it. Yes, call the next.
Item number 8.
Rejected upon all the respondent except respondent number 2. Postal remark, your law. But the respondent number 2 is presenting respondent number 1. That is similar. Respondent number 1 is being represented by respondent number 2. Can you see page 51, my lord? Ratnakar Pandhari is the General Secretary of the respondent number 1. Being represented by its General Secretary, namely C. Ratnakar Pandhari. Page 51, my lord. Well, earlier we have filed the affidavit of service, my lord. That is on the record, my lord.
When has the service been effected? Fourteen, 15 just has been served. Let it come after the holidays.
It may be granted to serve fresh to the respondent, but
Item number 9.
Milord, I appear for respondent number 1, 2, 4, and 5.
Well, I am for 3 UPSC.
I have
For
UPSC.
PSC,
Union Public Service Commission.
UPSC.
Number 3.
I am for the petition.
But in the tribunal, I appeared on behalf of all the respondents.
Huh?
My senior friend is appeared on behalf of the ministry.
All are represented now. Yes.
On the previous occasion, which I heard from my advocate on record, that the prayer are the same in the two-way application before the tribunal,
Earlier and present way.
earlier and present,
Yes.
which I heard just your lordship raise this point, whether there is any res judicata or not. But in the facts and circumstances of this case, no res judicata lies. Why? Because I filed the second OA on the by dint of the order passed by this coordinate bench, and on the basis of that order, I go to the tribunal, file the second OA application.
For the same relief.
Yes, relief is the
Where is
same.
the coordinate bench order?
Yes, page 318. Because I have no other relief. Only one relief is for me. That is, even if I have been allowed to file another OA, then also I will pray same thing. Not 318. আরে দাঁড়া, ওয়েট কর। জোসেফ খুব ভালো জোসেফ।
Yes.
হাইকোর্টের যে অর্ডারটা দিবঙ্কর দত্তের যে অর্ডারটা কোন জায়গায় এখানে কোথাও বলা নেই ম্যাটার হ্যাজ বিন রিমান্ডেড ব্যাক, কোথাও বলা নেই। ওইটা মিস ইন্টারপ্রিটেশন করছে।
So where is the liberty granted by this court?
Look, no liberty is there.
Then-
Because liberty is not necessary at all.
No,
It's
no.
not required at all. Direction is there. The coordinate bench, the highest, Lord, I cannot interpret the order of the Honorable High Court.
Nobody can.
No, your lordship can do as per Article 141. আরে আমায় বলতে দেন ভাই।
আরে
Why you are addressing him?
No, no.
You address us.
He's disturbing me. Sorry,
Is something new. Yes.
Lord, as per Article 141, my lord, the coordinate judiciary, my lord, your lordship sitting
141,
Article
141
141, my lord.
High Court.
What?
How Article 141 the High Court?
141 of the Constitution of India.
How it will apply to the High Court?
Yes, my lord, I am submitting this, my lord. We cannot interpret the order of the Honorable High Court because I am standing in front of the highest judiciary of the state who have the power because, my lord, This bench is not the subordinate judiciary.
This is a
Your
coordinate bench. We are bound by the earlier orders.
Equal strength of bench passed the order.
We are bound by the earlier order. By a coordinate
Yes,
bench. Yes.
Yes,
We are
I
not
want to
here to.
submit this. Yes,
Yes.
I want to submit
We
this
cannot.
because both the benches are equal strength. Of
Yes.
bench. And my lord, I cannot interpret, but after meaningful reading, I will understand what order had been passed.
So let
by
us
the
see
court.
where is the direction. Let us see where is
Lord,
the
the last line
Yes.
at page 319,
Yes.
we pity. Lord, this paragraph starts from, we pity the petitioner who had to suffer an order of dismissal on the verge of his retirement from service, but interference by the tribunal or court would be warranted. I am not interpreting. Lord, what do you mean by legal meaning of warrant? I want to place only this word, the dictionary meaning, legal dictionary meaning of this word. The warrant means direction. I am not interpreting. Lord, first I am handing over. Lord, sorry, I have only one copy. I am handing over the Black's Law Dictionary.
It does not say warrant. It says would be warranted. It says it can be under such
Lord,
circumstance.
in future would be warranted. That means in future I have the right because the court directed. Lord, kindly have a look into the meaning, Lord. From I brought
That
only
is that much we are not required to be shown. We understand what warrant means and what is the
yes,
warrant means command.
yes. Lord, from the both dictionaries, the
Yes.
law of lexicon as well as the Black's Law Dictionary, the warrant were used in the orders.
Yes.
That means the direction upon the
Yes.
lower judiciary.
Correct.
Therefore, the direction given to the tribunal, and I filed the another way application, not on the same issue. May Lord kindly consider my submission. Not your lordship will not go through the relief, but there are so many. There's maybe so many issues for which the prayer may be the same, but the CPC section 11 of the CPC says that yes, the issue to be adjudicated.
No, CPC will not apply. Neither applies to the tribunal nor applies to the High Court.
No, my lord, in the writ petition, my lord, under Article 226, the CPC is applicable. My lord.
No, sir. We know otherwise. CPC is not applicable. The principles do apply to every proceeding, but CPC does not apply.
My lord, the order passed by the tribunal,
Yes.
my lord, deal with the point of res judicata.
No.
Therefore, in the writ petition, my lord, yes, yes.
It does not apply to the tribunal also. It does not apply to the High Court also.
But my lord, it is written in the order, my lord. Kindly have a look into the order
Yes,
passed by
let
the
us
tribunal.
let us see.
My lord, last but one page, my lord. Inner page 4 of the tribunal's order, my lord. Yes.
See section 22 of the Administrative Tribunals Act.
My lord, sorry, I left this book, my lord.
Please, sir, have a look. Sorry, it is marked.
তোমার কাছে এক্সট্রা কপি আছে একটা ওয়ের রিট পিটিশনের কটা কপি আছে ডব্লিউপিসির কপি আছে
Tribunal shall not be bound by the procedure in the civil procedure code. The statute says in so many words.
তাই তো পড়েছে।
That is the statutory mandate.
No, Lord, may I submit, my lord?
Yes.
My lord, the maxim is the one, generally a specialibus non-derogant.
Yes.
When there is the special statute, the general provisions of the law will not be applicable.
Yes.
But that maxim is adumbrated here. My lord, but, my lord, kindly, may I read it, my lord? A tribunal shall not be
Natural
bound.
justice. Tribunal is to be
Natural
guided by natural justice.
Natural justice.
That is a standard provision in the statute.
For
In many statutes, it says not bound by CPC but natural justice.
My lord, what's happened, my lord? I will take another day. My lord, to do the justice or for complete justice,
it is written in our application at the end that for the ends of justice,
See,
the
this
natural
much-
justice to be followed.
This much we are clear.
And
Unless the High Court permitted you, you could not approach the tribunal twice.
definitely, my lord.
There can be no
And
two
my lord,
opinion about this.
that order which I embanked upon page 319 passed by the coordinate bench. I am embanking upon this order. Because the issue is not decided, my
We
lord.
have understood what you are saying.
My lord.
Yes.
Therefore, my lord, the issue which is left in the earlier way application, that issue is incorporated in the new one.
Can we have the book back?
Only disproportionate punishment ground was not there in the earlier way application. Hence, the honorable division bench directed to go and raise that new issue. My humble submission is your lordship should not go through the prayer, should consider the issue.
And where is the tribunal's order passed in earlier way?
Yes, my lord. My lord, page 298. জজ সাহেব জিজ্ঞেস করলো
Three 390.
My lord, page 298.
আগের একটা ডিসমিস হয়েছে আগের ওর একটা ডিসমিস হয়েছে আগের একটা
And where is the prayer made in the second OA?
Second. Page 183. May I be allowed to referring one page, my lord?
Just just give us a minute. What is the second OA number?
OA number 350/1180 of 2021.
This is the order passed in this way, which is under in the writ petition.
না ওটা কেন হবে? ওটা তো 1181 তো সেকেন্ড ওয়েটা তো 1181 1180
Yes.
My lord, kindly have a look into page 181. This is the grounds for filing the second OA. Page 181. My lord, ground number 10, 11 and 12. The grounds laid down here only for disproportionate punishment, which was not there in the earlier application. Therefore, my lord, in the second OA application, the issue is completely different. This is my humble submission, my lord. Page 41 is the grounds for in earlier OA application, and page 181 for the present. Yes.
Yes.
But I leave it to your lordship. My humble submission is completed. This is my case only.
And in the earlier OA, there was no issue of disproportionate punishment.
No, my lord. No, page 41. There is no ground. Page 41. There is no ground in this issue. But only this point is taken in the second OA application. Otherwise, I will leave the court. Because the issue,
No, but then what prevented you from approaching the disciplinary authority to reconsider the punishment?
my lord, in this case, my lord, the President of India passed the order. In the statute, my lord, there is no provision for appeal.
We are not saying appeal.
And
For reconsidering the quantum of punishment, you could have asked the authority.
my lord, I did not. My lord, I not done it, my lord.
And you retired in 17. You attained the superannuation in 17.
My lord,
Dismissal in 14.
my lord.
What can be done now?
My lord. And my lord, OA filed in 2019.
Yes, that is also belated.
No, 19. My lord, OA filed in 14.
First way.
2014, my lord.
First way.
First way. And my lord, if your lords will not entertain me, my lord, I will be remediless. As of now, my lord, the petitioner will be remediless, my lord.
He is remediless for a reason. Just see the way the OA has been filed and what argument has been done. Who is responsible for his present situation? That is why the court records, we pity the petitioner. Would be. Yes, what do you have to say?
My lord, I place, my lord, the judgment delivered in first way by the learned tribunal.
We have gone through it, sir.
And my lord, here only I will refer, my lord, the paragraph 5.
8 is relevant.
My lord, paragraph 5, my lord, there is a reference of a case of the Honorable Supreme Court.
Paragraph 9.
Paragraph 5. 301 of the paper book, my lord. Here, my lord, para 11 said that the Supreme Court of India in civil appeal number 2093 of 2007, Panchmahal, Vadodara, Gramin Bank versus others, VDM, Parmar, observed that on an examination of the equity inquiry report, we find that there were as many as 10 charges against DM Parmar, and the charges were of serious nature. And out of these charges, only one charge was not fully proved, one charge was partly proved, and one charge was deleted. And in the instant case, my lord, in the instant case, there are 8 charges, and all are the serious charges, and all are proved. Kindly have a look, my lord, at the inquiry report, my lord. That is, my lord, at page 231. 231 is the finding of the inquiry officer. All the 8 charges were approved, and these are the serious charges. But the petitioner took loan, heavy loan from the bank, 3 banks, and my lord, without any intimation, without any information, did not repay. These were the serious charges. That's why this, my lord, the punishment has been given. Major punishment has been given.
Your earlier OA is at page 41.
My lord. Rounds is at page 40. My lord, page 41, paragraph 5.
Then why the tribunal, this judgment has been placed by the respondents? He will limit, he's saying is only the quantum of punishment. That is the only issue, nothing else.
Nothing.
So now he is not questioning the validity of the proceedings. He is not questioning the punishment, but the quantum. He is not questioning the finding. He wants that this should be read as a liberty. It can be read as a liberty.
But this, looking at the charges, 8 charges.
Maybe we don't know. That is not the issue here.
Yes.
Yes, take down.
My lord, I am drawing your attention 3 paragraphs.
336.
Yes, one. 336. Paragraph 8.1, 9 and 10. Yes, 336.
Yes, dismissed High Court, therefore way to be dismissed.
Yes.
Then para 9.
Para 9 and para 2.
Para 9 again you have reproduced the same thing which has been noted in the tribunal's order. The same thing. Yes.
No, earlier in the High Court order, nowhere it has said that it has been remanded.
All right. Heard land counsel for the petitioner.
Item number 10.
Item 10, my lord, your lordship may look at the last order, wherein your lordship was directed whether I am a super specialist or a court specialist. My lord,
Before the petition, this matter will
Just after the vacation. Just after the vacation.
not after vacation.
Please, yes,
Better.
give a date.
I'll put it.
16th,
it is at 2 p.m. my lord. Can it be at 2 p.m.?
just after the ensuing summer vacation on 16th. No, if it is not fixed now, then it will not be fixed. It will come up.
Item number 11.
In this matter, I'm appealing on behalf of respondent number 1.
Yes,
Virtually, Lordship, can you allow me to appear virtually?
yes.
May it please your lordship. Beloved, yesterday your lordship adjourned its matter to submit the 2 copies of the unmarked decision, beloved. Petitioner came before your lordship for family pension.
Oh, one copy you have given unmarked, only the other one is true.
দুটোই দিন এটা অন্য বই SCW থেকে কপি করা Your lordship, the Xerox copy is from SCW, EIR SCW, and that is from the
AIR.
yes.
So you want to rely on that?
No, both are same judgment.
So you have given one copy. Why should you give another one?
তিনটে যায় বাবা
Are the paragraphs tallying in both the reports?
Huh?
Are the paragraphs tallying in both the reports?
Yes, my lord, because both are EIR's judgment.
In SCC, sometimes there is a different paging.
My lord, I moved a similar matter before your lordship in the earlier occasion, and your lordship passed this judgment order. কোথায় 19 তাই তো 9 ফাইন বলবেন না আমার দেখুন আমি দিয়েছিলাম AIR 2000 Supreme Court 3160.
So what is wrong with the order? Tell us.
Sorry, my lord.
What is wrong with the tribunal's order?
Because your lordship kindly come to the paragraph 19 of the Supreme Court judgment, my lord. High Court.
No, what is it that you want to support by the Supreme Court judgment? What is how this order is infirm? What is the infirmity that you would like to highlight by relying on the Supreme Court judgment? Reading the Supreme Court judgment for which submission that you are making?
Ground, my lord.
Yes.
Because your
It's not a delay ground. It is not a delay and latches. It is a bar of limitation. That latitude, whether it is there under the statute, can you rely on such a judgment regarding exercise of jurisdiction under Article 226 in a matter concerning exercise of jurisdiction by the tribunal, which is bound by limitation in the statute?
my lord, after the death of the person
In 2007,
in the 2007, the family pension is pending, but not paid. Matter is the cause of action is continuing, my lord. Authority, it is duty of the authority.
cause of action continues when you are a pensioner. A cause of action can continue if you are a pensioner, if you are getting it every month or you are being denied every month. That is not the issue here. The issue here is that you lack the qualifying service. You were never a pensioner. He died in 2007. Prior to that, he was not a pensioner.
No, not after the death of the husband. She is entitled for the family pension.
So he died before that. He was entitled to pension. He never got pension.
No, but
You never got
because
family
he was
pension.
in service.
He died while in harness.
Yes, my lord.
From where do we get this fact? Show us.
Your lordship. Page 21 of my application. It is clearly that the husband of the applicant joined the Eastern Regional Electricity Board as a
Page 21 of the OA.
OA. Page 21. Inner page 11, 2.
2.
Roman 2. Regional Electricity Board as an unskilled Mazdoor on or about 17/2/1984 to 13/8/1986, and since 14/8/1986 rendered his service as a work charge employee as assistant fitter till 31/12/1994. Thereafter, on 1/1/1995, the husband of the applicant permanently absorbed in the Power Grid Corporation of India Limited and died on 22/2/2007 and entitled for the pension and gratuity for the period rendered service in the Eastern Regional Electricity Board, and thus the applicant is entitled for family pension.
There is no statement that he died while in harness. There is no such a statement. You are giving a sequence of events. He was erstwhile working in such and such organization. Thereafter, he came here, he was absorbed. He died on such and such date. You don't say he died before attaining the age of superannuation. There is no such a vermin.
Yeah, I can't improve the case.
No, that's why we said, please read it. And we can't find it. We are trying to see whether there is any.
But, my lord, this is a writ court, my lord. For ends of justice.
This is the writ court examining the jurisdiction by the tribunal under the Administrative Tribunals Act. We are not here. We cannot be approached directly for the relief. That is the judgment in L. Chandra Kumar. You must have seen. The tribunal remains the court of first instance.
But, my lord, pension is the petitioner's constitutional and human right.
No, yesterday you were trying to show us something. You had just one copy of that document. We don't know. We don't remember what it was.
No, one the copy of your lordship's judgment order. In a similar matter, my lord, your lordship passes এটা জজ সাহেবকে দিয়ে দিন, দুটো আছে।
What is this? How this order can be considered by any bench? This is not a final order.
Not the consideration. But
It was this. It was the tribunal disposed of the matter after the reply.
after the reply, my lord, there is no whisper of any delay or something else.
Was the reply filed? Mr. Bagh, was a reply filed before the
No,
tribunal?
my lord, no reply was there.
এখানে নয়, ওখানে, এখানে।
You have a copy?
Yes, my lord, I have.
And that occurs to status may be clear from the side of the guard. See,
এটা জজ
71 account number.
একটা সরি রিপ্লাই, এটা ট্রাইব্যুনালের রিপ্লাই।
টাকা জমা করতে অ্যাকাউন্ট নাম্বারটা চাই, আমি কিছু কোথাও
না না, টেলিগ্রাউন্ডে কোনো হুইসপার নেই। এটা তুমি দেখুন, আর জজের নামে
Give it back.
Give it back. Let's see what the chat.
Nothing can be done.
Dispositor. Dispositor. Will be asked for it's everything.
But that is there. But the tribunal has also considered your entitlement.
Sorry, my lord.
The tribunal has also considered your entitlement. Lack of qualifying service has been taken note of by the tribunal.
That judgment, my lord, your lordship kindly come to page 39. The principal bench of the administrative tribunal passed the judgment, my lord, in pensionary benefit. That was challenged by the government of India before the Delhi High Court, and Delhi High Court reversed that judgment. They passed whether the person worked in a permanent and non-permanent post, that doesn't matter. Completion of the 10 years of or completion of the statutory period entitled for the pension. Delhi High Court's judgment, my lord, page 41. Inner page 20. Annexure A7. Oh, sorry. Page 41.
But you did not serve for 10 years.
More than 10 years.
Not in the power grid.
Yes. They, in 1196, I'm 1195, I am absorbed in a permanent post. '84 to '94, I served in a Eastern Regional Electricity Board. And 1195, I am absorbed in a permanent post in the Power Grid Corporation.
Yes. From 95 till which date you served?
My lord, demise of the petitioner's husband is 22 to...
That is not, it is not clear that on that day you were in service. There is no such averment. And they say you don't have the 10-year qualifying service.
But total, my lord...
Now, total, where does the principal bench says that total has to be taken?
Delhi High Court, my lord. Your Lordship, kindly see the judgment of the Delhi High Court, because
There was an option given to you at the time of absorption. Do you want to retain the government service pension or not? You said no. I want the pension from Power Grid Corporation, and whatever dues you are entitled to, that has all been enumerated in their reply. There is the question of counting any other period. Cannot be. You exercise your husband exercised the option while he was alive. How you can resile from his exercise of option? You cannot. After seeing that, we are saying that there is no scope. Even if we ask them to file an opposition, the same thing will come again. Will not improve your case in any way. What was his total length of service as per the reply in the Power Grid?
Power Grid, my lord, since 1/1/1995 to
No, it's in one paragraph they have stated. Let us see. They have given all the dates. 2-3 paragraphs. It has been repeated.
was the reply.
In the reply, the entire thing is there.
এটা ওদের reply, আমার দিকটা Yes, my lord, rejoined. Judge সাহেব একটু দিয়ে দিন. It's our rejoined.
Reply.
No, my lord, rejoined.
No, reply. Show us the reply of the Power Grid.
Reply of Union of India. এটা ট্রাইব্যুনালের
Total qualifying. 8 years, 11 months.
Yes, my lord.
That's all.
No, but I will get it, because according to Delhi High Court's judgment, your lordship, kindly please take the trouble, my lord.
এই ইয়েটা করে ফেলেছে ওইগুলো শেষ করো
চলছে Page 41, my lord, Delhi High Court's judgment, because the tribunal's judge principle.
K.C. Rana approached the tribunal.
Yes.
He had more than 10 years service.
No, clearly the Delhi High Court said if it is less than that, we'll get the pension. This that is and reference was, my lord, O.P. Sharma, 202(1), CLR, page 1088.
See, there he had given an option to continue under the central government rules. Here you have given an option for the power grid rules. Therefore, the Government of India provisions were applied to him and the past service was directed to be counted. In your case, they have annexed your option. You have exercised the option for remaining in the power grid. You have not said anywhere in your OA that we had exercised an option for this Government of India. Page 42. Second paragraph.
Hello, Your Lordship, kindly come to the page.
Come to page 43, second paragraph. Read it.
Your Lordship, kindly come to page 42.
Please
Second
come to
paragraph.
43.
Yes.
Next page, second paragraph. Why the relief was granted, it is there. He went to the Power Grid Corporation on the basis of an option for continuing with the central government pension, and therefore that period could not be deprived. He could not be deprived of. In your case, you gave an option for going in with the Power Grid Corporation rules. That is their stand. Annexure 2 is your option. They have enclosed the option also. Yes, take down. Land Council for the petitioner and the Land Council.
Live on YouTube.
Number 12.
Lordship, I am for the petitioner, but Union of India here. Lordship, I am praying for after kindly keep this matter after vacation, Lordship, because of
As played list after the summer period.
vacation. Department not yet submitted. That is the reason.
Yes, yes, as played after vacation.
Bit of service, Lordship, can be kept on the record.
No, no, come on that.
They come in the head on it. Okay.
Thirteen.
13 my lord, I remember. Seeing that.
Nothing, my lord,
I appeared for the matter.
Lord, I appear for the Union of India, my lord. I'm
ESI.
No, Provident Fund, my lord.
Provident Fund.
My lord, I have not been served with a copy, my lord. Just have taken instruction, my lord. Neither we have received, not.
But only it was served upon the respondents number 1 to 7. Most probably it has not.
One is, my lord, is the pro forma respondent, my lord. And two, I think, Delhi.
My lord, in that event, my lord, we will be serving a copy, my lord, let liberty be given to the move the vacation bench because my lord, the urgency of the matter, my lord.
Is required.
Without liberty, you cannot move.
Since it is matter is listed before your lordship, my lord, without liberty.
Where tribunal fixed the matter on 18 June 2025, my lord. 18 June matter is fixed before the learned tribunal, my lord. This is with regard to transfer, my lord.
This is it.
You have joined the transfer place. Then why the court should hear your matter?
But subject to correction by my lord, there is no mandatory rule, my lord, that I must join thereafter.
There is judgment of the Supreme Court
Yes. I have
that before
considered
approaching the High Court, you should, or the court, you should join the transfer place of
I have gone through the judgment, my lord has
Yes.
also in of one of your lordship's decision, my lord has referred the judgment, my lord.
Yes.
As such, my lord, I could not find, my lord, that is a mandatory that he should join, my lord. He is sick, my lord. He has given
Supreme Court judgment is not mandatory.
But that judgment was passed in that facts and circumstances.
Where the rule has been relied upon that after joining he has to file.
But here, my lord, we have challenged the order of transfer.
You are trying to escape the Supreme Court judgment by saying that in those facts it has been rendered. As if in that case the rule of the service required that you can challenge the transfer order only after joining. How a rule can be framed like this?
Your lordship has passed an order, my lord. I have got the copy of the judgment, my lord,
Yes.
from here, where my lord
No
has
urgency,
this
sir.
I have
No,
been
told
this
not
point
that
point
out
was
of
raised, my lord.
122, all have been joined, excepting this.
Yes. Then we'll see, we'll consider. You proceed. Let us see. Without joining, whether you can proceed, that is the first issue. Now address us on this point. And why at this stage, when only a reply is called for, we should interfere?
But,
These are the two issues. Then we'll see anything else.
my lord, that is marked, my lord. The point was raised by the respondents to that petition disposed of by your lordship, my lord. That point was considered, my lord. In that matter, what happened, my lord? There was a stay prayed for, my lord. Stay was granted till the disposal of the matter before the tribunal. Thereafter, my lord, after for 2 years, matter proceeded before this honorable court, before your lordship, my lord. After 2 years, my lord, order was matter was disposed of. But in between, there was no stay. It was urged by the respondent, my lord, that since he has not joined, nothing can be considered. Your lordship has held, my lord, that in view of the stay granted, my lord, they did not join.
Here there is no stay.
Yes, that I appreciate. That here there is no stay, my lord. Stay has been refused, my lord. Immediately we move before this honorable court. If this honorable court, my lord, refuses the stay, I have to join.
Therefore, we are asking you, without your joining, in view of the specific mandate of the Supreme Court, why we should exercise our discretionary jurisdiction in respect of a transfer, which is an incident of service. You have no right to continue at the same place.
But I have not been released in formal manner, my lord. I have not been handed over.
They will do it.
Release.
They will do it. They will do it tomorrow. They will.
So far as the
That is no ground that they have not released. You go and take the release. Who is stopping you?
Already been released.
Transfer has been made, my lord, in total violation of the transfer policy.
No policy mandatory is mandatory that it has to be done in that way. The law is very well settled.
But here, my lord, option was called for, my lord.
Maybe. Option does not create a right.
Vacancy, my lord. There was vacancy in spite of.
Maybe they want someone better. That is the latitude given in a transfer matter, sir. You are arguing a transfer matter. Please be conscious.
But
there is no right whatsoever.
So far as the point raised by the other side, my lord, that I should join thereafter. I can.
That is also very much mandatory. That is also very much mandatory.
That is the judgment, my lord, rendered is 2006 volume 9 SCC, my lord.
There are so many judgments on this point.
My lord, your lordship
Time and again the Supreme Court says.
Lordship judgment, my lord, I have handed over, my lord. This point was raised, my lord, but there was no point that it is mandatory for
No, there was a stay. Now I remember.
He was for a limited period.
No, he has already been released. No, released by 1st May 2025, my lord.
We are not concerned. Release, not release does not make any difference. It has no bearing on his claim.
There is no finding, my lord, in your lordship that mandatory. There was a limited stay. Thereafter, there was.
Then we'll give you a judgment right now.
Continued,
We will give you judgment. Where is my note? We'll give you judgment at least 5. That without joining the High Court should not entertain.
There are judgments, some judgments are there, my lord, but
yes,
that particular factions are.
Sorry, there's nothing. You go on 18th, or you come after vacation, or you argue tomorrow, whatever. You tell us. Tomorrow. Oh, now you come after the holidays. Sorry. Not for a transfer matter, we are not going to take it. You go and join or you will suffer the consequence. What can be done? Just after the holidays.
But tomorrow or after?
After the holidays.
But let leave be given, my to move.
No such urgency, sir. We can record today that since you have not joined, we refuse to direct such liberty.
Let that order be passed. Let that order be passed. Then, my lord, let it be taken up after vacation.
After holidays. List after the holidays. Serve a copy. Let a copy be served on the learned counsel for your for.
No, I think on behalf of New
Give your appearance, please.
I am appearing on behalf of the petitioner.
One should think 1,000 times before
I am appearing on behalf of the petitioner and challenging the order passed by the Honorable Learned Tribunal, which is at
Does not have the requisite qualification. Minimum 8 standard.
After death of my father, I applied before the authority. And
He is the only legal heir.
if there are mother and the petitioner and sister, but they have give no objection. They have no.
Who is qualified? Ask them to apply. What is this? How can you?
As per their rules, no one is qualified. But kindly come to page, Lordship. There is a notification. Lordship, kindly come to page 45. Start from 45 and the paragraph is 47, Lordship. Last paragraph B.
D.
Relaxation in educational qualification may be granted in eligible cases for appointment of Group D post in consultation with the finance department.
Have you applied for relaxation?
Lordship, I am applied.
Where is your application for relaxation?
My application is page 44. Initially,
For relaxation, you have made a prayer.
yes, Lordship. Page 44. I indicate the notification. But Lordship, it is problem is this.
How I will understand, madam?
This is the main problem, Lordship. This is my fault. Here it is indicated, the notification is indicated.
No, we are asking you, did you apply for relaxation?
No, Lordship.
No.
Specific way, there is no I am not applied.
Then if you applied, they could have considered.
Direct that then Lordship kindly direct me to apply before.
There are two things. One is that you can apply and they will take. We don't know how much time and what. Nobody else is qualified in the family.
Mother and sister is
Illiterate.
Yeah.
she is, and they are in a very bad condition. Financially, they are very bad condition, Lordship.
So what is the parameter for giving relaxation?
One of there must be a first funding that their financial disability.
That
Financial disability.
So that 3-member committee has to look into.
Yeah. Then one of first, second, they first must have a educational qualifications.
If must have, then where is the question of relaxation? We are asking you, how do you consider the relaxation?
Kindly see the notification issued on page 45 for a moment. 3rd December 2023. And page 47.
Yes.
Last Lordship.
Why did you not annex the complete thing? Only up to page 3 and then you have not annexed.
Yes. I will go to the work. Spiral binding. Spiral binding.
Annex the notification.
You have?
Yes,
Yes.
page 45.
Yes.
And,
No, but this is complete.
No, not complete.
Can't be.
Can't be page 47. After that,
there
after
has
47 there are there. Page 83.
Eligible case. How do you identify the eligible case? If we are just, please hear us for a moment.
Page 84.
If there is a family which otherwise you find it is eligible on the parameter of indigency, and there is no person qualified therein, will that be eligible case for relaxation of education, or it will not be?
No, what of section 6 is the clause 6, paragraph 6 is the eligibility. First financial, 90% of the income.
Therefore, we are saying, is there any assessment of these parameters?
First, what are the conditions mentioned in paragraph 6 has to fulfill?
Who has assessed that he does not fulfill?
But can you see the impugn order, page 40 for a moment?
Page 40?
Yes. 42.
There is a finding that the income is sufficient.
Yes.
Order is passed by the authority, Lordship.
Oh. 42.
Up to class 4 standard.
That we are not asking you. That is admitted position. When there is a provision in your circular for granting relaxation, when do you grant it? To whom you will grant it?
Provided clause 6 is fulfilled.
What is clause 6?
Clause 6, income criteria.
So who will assess whether she...
Three-man committee is there.
Has it been done?
Until unless these conditions are not there, that will not.
So
go
why
to
you have not done it?
But it will not go to the committee. First, what are the within the age of first, second educational qualifications, financial criteria, if fulfilled, then you will go to the committee. Committee will consider again financial conditions.
So if I fulfill everything, then the committee will consider whether to relax or not to relax.
No, then committee will hear him.
And we are asking you, when there is a provision for relaxation, it is redundant or it has some meaning?
It has some meaning.
Then in which case you will give?
Yes. Clause 3. Clause 14.
What is clause 14?
Clause 6 is the eligibility conditions.
Yes.
Then Malad.
This is to be done by which authority?
First by the government. In case of police.
No, his employee. His father was working in Public Works Department.
PWD.
So PWD, who is the competent authority?
Secretary. First power has been given to the person.
So
then to go to
why such a provision has been made when it is not being given effect to?
Then ultimately it will go to the at page.
Your claim has been rejected by the authorities.
Yes.
Yes, sir.
Where is the rejection order?
Page 42. Page 42.
42 and type portion is 42A, Lordship.
What is this? How can you reject like this due to lack of educational qualification? We have seen due to lack of educational qualification.
Yes.
Then where is the consideration whether he is entitled to relaxation or until he fulfills the educational qualification, you will not consider.
No. First, he must be within the age. Number 2, financial condition fulfilled. Then educational qualifications all fulfilled. Then we'll go to the.
So he is over age.
No, within the age.
He is within age. And his financial condition is very good.
No, financial condition. First product, test is the
financial condition is very good.
No, that has not been.
Then how are you proceeding to reject like this?
First one of condition, he must have a educational qualification.
My God.
No, he must apply that because I don't have a qualification.
Then why have you incorporated such a provision for relaxation?
Well, can you see?
You say eligible cases. What is the meaning of eligible cases? Eligible cases when he qualifies the educational qualification.
One eligible conditions is that.
Again, you will say the same thing. Where is the assessment we are asking you?
Just give me 1 second.
Slipshod manner rejection. One line order, not educationally qualified.
Just.
This is the way you implement your policy.
Can you see the procedure? Paragraph 10.
We don't want to see. We want you to show how you have followed the procedure. Who has considered his financial status? How you have rejected by a one-line order?
If he does not have the educational qualification, then what will happen?
Then he will be considered for relaxation if he is eligible. That is what your rule says, your circular.
Can you see the circular?
What circular? Read your circular. Unsustainable order. Non-application of mind is apparent from the order.
Yeah, but it is known to her that he does not have the requisite qualification. He could have applied because I don't have a qualification. Kindly consider my case after relaxation.
So therefore, now you are saying something which you should have said at the very beginning. Even if she has not, if she is or he is a fourth pass person, you expect him to have so much of. You should not assist him. You are not obliged to assist him in this process.
No, certainly.
Then why you have not done
model employer, I being it.
No, your circular demands, it directs that you should assist him. Why you have not done it? Why this slipshod manner you have taken it up?
Only difficulty is page 47. He has relaxed pension part of the notification. Page 47.
We are looking at your compilation. You have given us the compilation. There is a provision that you have to render assistance to such persons in obtaining the compassionate appointment, and you are rejecting by a one-line order.
No matter if my friend clients can apply for relaxation of conditions, then certainly government will consider. But because when a transport staff, nowadays.
Just imagine the problem that they must be going through. He has left behind a wife,
unfortunate death,
one daughter and one son, all are unqualified. It may be a different circumstance if you make an inquiry and you find that they are having a lot of property and a lot of income. Then you may say, no question for giving any relaxation. There is no consideration. One line order you reject, not educationally qualified.
Application, I am enclosing all my documents.
Yes, on the format, everything is given. That format, that is why they insist that you give on format within 6 months and now 2 years perhaps. So why do you take the format if you don't consider anything?
In the format, qualification is mentioned.
My God.
And income is also mentioned. And last page is also mentioned. And what is the pension?
Find out. You will have to examine it. We are going to pass the order tomorrow.